Hello everybody, so welcome back to the English Law Channel. So going on about the Law of Property Act 1925 and looking at how there's registered and unregistered title. So we talked about fee simple beforehand. You know, sometimes it can be entailed away. Alfred has it for life, passes to Belinda in fee simple, and so on. So in that case, Alfred would have the life estate, Belinda would have the remainder interest, and these would be equitable. Those states aren't under Section 1.1 of the Law of Property Act 1925. Okay, that they can't be legal, but we'll get on to those. So a fee simple owner who's granted a lease is held to be in possession, technically speaking, because possession that includes receiving rents and profits from the land, or the right to receive them even though they're not actually received. So a landlord holds legal estate in land despite someone else being the sole possessor through a lease. So you have to realise that the Law of Property Act 1925 sections 1 and 2 simply says that whatever estates and interests can exist at law. So it can be a legal estate or interest. We have to make sure that the legal estate or interest is created by the right formalities, as we say. For instance, in most cases, you need a deed to convey this or to set up a trust estate. That's as per Section 52 of the Law of Property Act. And a new deed is needed to transfer from a vendor, that's someone selling, to a purchaser. And you can't simply hand over the extant deeds. So this will demonstrate there's a root of title, as in the person who is transferring the title actually has the right to that title. So if you don't use a deed when creating or transferring a new interest or estate, then the person who receives it will not receive the legal interest or estate properly. So then you have to wonder why, what will the intended recipient receive? Because when we come to land law, there's a specifically enforceable contract about transferring legal estate. So there has to be a contract which is consonant with the Law of Property Miscellaneous Provisions Act 1925, Section 2. So an equitable version of the interest or the estate will be granted to the intended recipient, because remember the old equitable maximum, equity looks as done what ought to be done. So from there on, the transferor, the one who's doing the transferring, still holds the legal estate or interest, and that's a constructive trust, and he's holding it on trust for the transferee, the person who was supposed to receive it. And the transferee's got equitable title because the legal conveyance has gone wrong through not going through the right formalities. Channel them down certain prescribed paths, as one jurisprudential scholar said. Well, let's look at unregistered land. How do titles work there? So the 1925 reforms and subsequent reforms, such as the Land Registration Act 2002, I'm going to deal with them later on. So it's strangely, how come there are two systems? Shouldn't it all be amalgamated into one? Anyway, what the successive Land Registration Acts have done is they've simplified the process of conveyancing and putting all titles onto a single register. And the Land Registration Act 2002 obliges people to register title whenever the land is transferred or subject to a first legal mortgage. So how come we even look at unregistered land? Because we know that according to the 1925 Land Registration Act, unregistered title was supposed to be there only for the time being, and that there was going to be phased out. And here we are 96 years later, and that still hasn't quite happened. It's kind of slower than anybody thought. It was assumed that within perhaps a decade it would be all gone. Anyway, so there are some defects. About 10% of land in England and Wales is still unregistered, and that is even though the 2002 Land Registration Act added more occasions in which land has to be registered. I mean, they could have a law simply saying, well, all land has to be registered, but would that be too authoritarian? Some people argue not. And so there are reasons you can choose to register your land if you want, and it's tried to incentivise that. So the government has got 2030 as a date by which they intend all land to be registered. Is that going to succeed? I suspect it won't, actually. Sometimes the land has been in the same hands for centuries, a same family or a charity, the Church of England, for example, so the title is still unregistered. Anyway, unregistered title is less and less important because there's less unregistered land around. Anyway, so because of the land register, we can work out who really has title to what. When an unregistered land is registered, then we discover which third-party interests there are, and these are enforceable against the holder of the title. And we can then judge what needs to be entered on the register, and bear in mind that these will bind a purchaser, sometimes regardless of registration, if they're kept off the register. Some other interests will be void because they were not protected for some reason. Anyway, so there's also a thing called overreaching. We'll come on to this. So coming back to the 1925 Law of Land Registration Act, a purchaser was going to be bound by legal interests whether he knew about them or not. Legal interests bind the world. Equitable interests don't. Okay, so legal interests, they have an effect on anyone else. So equitable rights are often overreachable, or else they're registrable as land charges. It's not charges in a fee that you have to pay. It's not charges in an accusation. It's some kind of a right. So overreaching is a process whereby the buyer of legal estate takes it without any extant equitable rights. So the buyer is able to defeat those equitable rights. Nobody else has got any rights over that land, only the buyer, if he overreaches it successfully. So the equitable rights, they don't simply disappear. They then become money, okay, and somebody gets money for those who's lost their equitable rights. So overreachable rights are usually of a familial kind. For instance, interests that exist in a trust. And registrable rights are usually business ones, easements, covenants, options, and so forth. Interests can be registered as land charges pursuant to the Land Charges Act 1972, and if they are not overreachable. So it's quite difficult to comprehend this because there's some equitable interests are overreachable and some others are registrable. Why is it? Well, that's because the way equitable interests work and how they can be protected. In a trust, we think the trustees are going to manage the assets in the trust, and that usually means they can buy and sell trust property. So the beneficiary, who's gaining from the trust, and the buyer. There's a trust asset, often land, and that's sold. The beneficiary's interests move from the asset to the proceeds of the sale, the money. If that wasn't the case, then the trustee wouldn't be able to sell any trust property. Conversely, what if you're looking with non-trust equitable interests? The holder of the interest needs the interest to continue to buy the land, even after the land is sold. So this is different from overreachable interests, because we don't want the interest to move from the land, which relates to the proceeds of the sale. We want it to stay in place, even though the land has changed hands. So when land is sold, overreaching makes sure the beneficial interest moves from the land to the proceeds, while registration allows non-trust equitable interests to carry on binding that land. So Lord Justice Robert Walker said in Birmingham Midshares Mortgage Services Limited and Sabwell in 2002, the essential distinction between commercial and family interests, they cannot sensibly shift from the land affected to the proceeds of sale. However, a family interest can do so, since the proceeds of sale could be used to buy another home. That's the end of the quotation. Overreaching is applicable to beneficial interests, and since the case called Sabwell, it seems the familial interests created by proprietary estoppel, which are similar to the beneficial interests. But it goes further, and it's more dubious whether we can extend overreaching applying to anything that's an unconscionable transaction, such as the Mortgage Express against Lambert, 2016. So there is overreaching, and it's not just about land, but all sorts of other types of property which are held on trust, although there are different mechanisms when it's not land. So anyway, we're looking at here an overreaching in land, pursuant to the Law Property Act 1925, Section 2. So the purchaser takes it free of any beneficial interests, so long as they pay purchase money to at least two of the trustees. That's as per the Law Property Act 1925, Section 2. Overreaching is useful because it allows purchase of legal estates in land to do so, freeing them from the risk that there'll be hidden equitable interest in the land. They didn't even have to look for them. So they freely alienate the property. They take the property and nobody else has got any interest on it. The new landholder can do whatever he wants with it. So overreaching is applicable in unregistered land, as well as in registered land. So it's available to those who are buying an estate in land and mortgagees, but not to the grantee of an easement that could be found in a conveyance, for example, Baker against Craggs in 2018. But bear in mind that overreaching with the sale is not made in good faith, even if the purchase money is paid to two or more trustees, such as HSBC Bank PLC against Ditch in 2019. That's a case. 2009. There's a case in point. So, how does overreaching help the beneficiaries? Well, let's assume the beneficiary wanted to take place. That's not always the case, though. The mechanism doesn't provide any absolute guarantee that two trustees will not run off with the beneficiary's money. And remember, their rights have been converted into money through overreaching. Anyway, the two trustee makes it trickier for the trustees to defraud the beneficiaries. Occasionally that occurs. Two trustee rule makes that more difficult and usually helps the beneficiaries. In the residential context, you might prefer an interested land to money because, it's a house and you want to be able to live in a house. That's enough at the moment. Toodaloo.